Hello, my name is Jay Chauhan. I am heading the group Angel Mentorship Group, and I'll be doing a video or a CPD program on the 15th of November. And any lawyer is or a student is invited to this program. And today in this video, I just want to give you an overview of what I will be talking about in that particular program. I just want to give you an overview of the profession in the real estate aspect of our practice. And as many of you know, that today is the 1st November 2018, and the Terraview is down. So a lot of the lawyers are worried, how do they close? So when the Terraview does not work, today we work electronically to make registration. In my time, we used to take the documents to the registry office and basically present it to the other lawyer, and the registrar or the clerk in the registrar's office, in the land title's office and registry office would stamp it, and that's the time of registration. So as we went electronic in the last few years, and the responsibility of the registrar to document the registry documents has now been shifted to the automation, to the machine. And the question I'm thinking about today is that how does our profession work in terms of the responsibility and the liability when the deal doesn't close in time? There'll be lots of problems, including insurance issues that can arise from the delayed closing because a judgment or execution can be registered on the title during the intervening period. And that's why in the registry system, there is an exact time in the minute when the document is registered, which is now done by the lawyers on the Terraview system. So I hope that those who are practicing will take the time and trouble to attend the seminar so we can debate these issues in terms of how the system works, how it has evolved, and what is our role in the system when we practice real estate law. So one thing that I want to just give you an overview of the profession in real estate is that perhaps fortunately or unfortunately, I'm not very sure, there are a very large number of lawyers are practicing real estate. So in the 90s, when the prices of the real estate went down, I had to practice until 90s, so almost 30 years, without any mistake in the entire 30-year period. And I used to charge about $1,000 plus for closing a real estate transaction, plus all the disbursements, land transfer tax and costs, etc. But when this 90s recession happened, it affected real estate practice. I had one full-time secretary that did nothing but real estate, very good income, paid bread and butter as they call it in the practice, and other secretaries did other areas of law, and we made very good income. But what happened at that time is that the competition between lawyers increased. So whilst the agents continued to charge a percentage, the lawyers started competing with each other for business, because many lawyers get what I would say stuck in one area of law and find it very hard to adjust to another area of law after a few years. So I didn't want to decrease my price of the purchase of the purchase or sale transaction. So mostly I lost the entire practice, and except for those clients who got to know me and valued the way that I did the report and the title search. And then more or less I phased out that practice. So today I am basically reflecting on what is the future of the real estate practice in the future. So one of the observations I make as of today for the Terraview is that when the machine takes over, and if you watch what has happened over the years, for example, the PIN number came along. So in the good old days, we used to measure the description of the property was called meets and bounds description of the property through a compass system of measuring the degrees moving north, east, west, south, and then describing the property in great description. I still remember that we used to sit down, the secretary and I would sit down, and to make sure the description was correct, you would read out a whole page of description of the meets and bounds description as it is called, and then we were sure that we were conveying the correct property. Today, all of it through mechanization got overnight, if you like, brought into the PIN system, property identification number, which it identified the property by the numbering system with the description set in the registry office. And when you identified the property on a deed, it was described no longer by the lengthy description that we sat down to review each time we conveyed, and got brought into just a numbering system. So similarly, it's my view that as time goes on, that more and more mechanization will happen in the profession, which will once again reduce our opportunity as lawyers to do something in that area and essentially make a living out of that area. So I would say to those who are practicing real estate that I would say that as lawyers, we should look forward to seeing what is possible. And since we are in a profession which is still private enterprise legal system where you pay the lawyer as you go, then we do not have in the province of Ontario the system of Quebec where there is no disagreement when the vendor wants to sell, the buyer wants to buy, and the notary says, okay, I sit here, register the deed, you go home, and the deal is closed. In the common law system, which comes from England, the registry office requires the understanding or the chain of title, it is called, for 40 years, and then you duck the chain out as the lawyer of the buyer. You made requisitions to the opposing counsel because we have a common law system which is adversarial. Anything we do, we always have one side, one interest in the conflict rules that dictates our judgment and our ability to advise. So we make requisitions, the opposite side answers the requisitions, and because of the nature of the, what I would say, practical nature of the real estate law, you basically try to shorten. If you're a solicitor for the vendor, you simply reply back and say, satisfy yourself. So half of the mechanized letters you will see in the conveyancing system are mechanized. And then over the time, in the good old days of my time, we wrote to write the letters. The secretary actually wrote a 3-page letter making what is called requisitions. Now, all of that has been automated by system, and there are several in the market, of which the most dominant is a computerized system called Conveyancer. And I hope that we'll be able to call the Conveyancer in this seminar also, because we did one seminar at the Osgood Hall on the issue of the real estate law and where it stands today. So some of it will be able to review also on the seminar coming up on the 15th of November in my office at 6 o'clock. But essentially my message to the profession is that the insurance came in the picture. More and more lawyers began to shorten their search function to basically what insurance wanted you to do. And you do the least amount of work, because today the way that you enter the real estate practice is to figure out in the neighborhood how much the lawyers are charging. Then you compete with them. So the prices in some places, not necessarily Richmond Hill, but places like Brampton, Scarborough, you quote a fee which is lower than your neighboring lawyer, and you try to track the client. And today that has gone down to very substantial amounts, and you can get a quote today for some ridiculous amount, if I may say so, of about $1,000 or sometimes less for the basic mortgage for the purchaser and the work to be done to get the title for your client as a purchaser. And the seller side is a little bit less, even less, so maybe about $650 or something in that range. But bigger properties are of course different. So this is the area of practice where I think you make the least amount of income unless you have a very large practice of volume and you're able to do a number of transactions all through the staff, and you simply observe the title and observe the key elements of what you need to do as a lawyer. But I think that one of the rules of professional conduct requires you to be responsible for what they do, and this is where the lawyers who practice real estate end up making about 37% of all the mistakes in negligence with the law pro in the profession. So to bring it to a summary of this seminar that I want to do on 15th November, I hope you come, is to say that if you can, I would look for different areas of law. And I think that unless you have a very large volume practice, that the making a living out of real estate has, in my opinion, numbered days, because it's only a question of time before all the variables that you can think of, like, for example, searching the municipal offices for the taxes, figuring out the side yard setback requirements, and determining the search of the title, are all essentially mechanical decisions, not entirely mechanical. The human judgment is that, is the title there? Is there a breach of the bylaw? But all of them are capable, in my opinion, to be mechanized with artificial intelligence, which is capable of understanding a large variables and figuring out the problem as well as the answer. And so in these days of computerization, it's a question of time alone that the practice will likely go computerized, and our role as lawyers will diminish in that area of practice. So if you're interested in finding other areas of law, join us at the Angel Mentorship Group. I look forward to seeing you on the 15th of November. And to join, please write to my office at Elham, ELHAM, @jchauhan.com, and hope to see you then. Thank you.